Good afternoon, everyone. My name is Ursula Leo. I am an employment law attorney here at Laddie Clark and Ryan, and I'm here today giving a lunch hour webinar on how to deal with challenging employees. So thank you for spending your lunch hour with me, for those of you who actually eat at 12 like me. The topic for today, how to deal with challenging employees, is a touchy subject. This is one of the largest turnouts I've had in the many years I've been having these presentations. So that shows you, right? If you're on this call as an employer, it's hard. It's hard to deal with challenging employees. We would hope it wouldn't be, but it is, right? When we look at the topics that we're going to cover today, I wanted to consider what certain areas are. I have to share my screen to start that off, though. So share. While we're waiting to get that on, is it on now? While we're waiting to get it on, is what I think some takeaways are, some important takeaways are, is don't ignore. When you have an employee who seems like they're creating a problem, that seems like they're not a good fit, we want to make sure we address that situation as soon as possible. And the way to deal with that can get intimidating because of all of the laws that exist, because changing law, because if you have civil service, if you have contracts or unions, it makes it more difficult. So what you want to remember is don't ignore it, right? Reach out, get advice from me, from another attorney, so that you understand what your requirements are. And you want to make sure you document. I can't say that enough. If it's not in writing, it didn't happen. So I want to make sure everyone is aware of that. Make sure you're documenting it so that we can confirm what we did for our employees. So 4 topics are: 1, employees who are just not a good fit. They're new to your organization. Maybe they've been there for a while. They've had changes. They're not a good fit. How do we deal with them? Employees who have performance issues, maybe a little bit easier, maybe not. And then illness, disability. We talk about the alphabet soup. When we've got illness and disability issues, that's the alphabet soup of the FMLA. We've now got paid sick leave, New Jersey Family Leave Act, New Jersey Family Leave Insurance. So I'm going to briefly touch on those. And then finally, whistleblowers, or that SEPA Act. Retaliation is much more investigated now by the state agencies, federal agencies. So you want to make sure that you're ensuring there's not retaliation in the workplace. So employees who just aren't a good fit. So you as the employer, it's your company. You can discipline, you can terminate, but again, we want to make sure that we're documenting the non-discriminatory reason for disciplinary action against any employee. My advice in a nutshell is hire slow and fire fast, right? I know a lot of employers have a probationary period. In municipal government, we have to have it. In private employment, we don't have to have a required probationary period. And I don't like it because I want you to be able to get rid of an employee at any time for any reason if it's day one. They come in, you don't like how they're interacting, you don't like something they said, that's okay. If it's not going to be a good fit, that's okay, but you're going to document the reasons. The longer you wait, the more you're giving that problem employee a chance to fit into what I call that box of protection, right? When we talk about the law against discrimination, it is a protection for protected categories: your race, your religion, your gender, your sex, right? Everyone fits into one of those boxes, but putting yourself into protection at the place of work is something that we don't want to be dealing with, right? Because now we've got to show that when we took an action, it's not because they said to us that they have a disability. It's not because they said to us they've been treated differently because of their race. So if there's a problem, take care of it quick rather than allowing those things to come up and then other problems that we're going to have to encounter in taking appropriate disciplinary action. So New Jersey is at-will employment, meaning you can be terminated for any reason or no reason at all, as long as it's not a discriminatory reason. So anytime. That's what at-will says. Examples, exclusions are, of course, if you have a contract, civil service, or a union. Then we're probably going to have to look at for-cause terminations and steps, progressive discipline within the process. But in general, most people are at will. You can get rid of them anytime for any reason, as long as it's not a discriminatory reason. So you're saying, okay, I can terminate anyone at any time, right? Technically, yes. But remember, we are in New Jersey. always document your reasons for termination, right? You let somebody go, 2 months later, they send you the letter saying it was wrongful termination. Do you have documents to show the real reasons? You don't have to tell them at time of termination, but you need to have a document that shows what it is so you can, if you're a large employer, maybe you don't remember, right? You want to make sure you're documenting it. Always follow up with a termination letter. If you let someone go, make sure you're following up. A form letter, quick thing, saying why they're let go. If someone resigns, it's different, right? Because they're not eligible for unemployment. So again, termination, resignation, you always want to document it. And always be ready to defend your actions so that we can show it's not a discriminatory decision. It was because it wasn't a good fit. It was for performance, whatever the true reason is. And we want to make sure our letter is appropriate, right? No good deed goes unpunished. No one ever wants to tell anybody that they were a poor employee, that they're a poor performer, that they didn't fit within the organization, but that happens. And I'd rather you put that in that termination letter than 6 months from now, try to litigate the matter and explain why it's not in that letter. If they were so bad in performing, why did you say it was a mutual parting of ways, right? Make sure your termination letter is accurate. So a lot of people like to use contracts. I do not think we should generally use contracts because that takes us out of our at-will world, discipline for any reason, no reason at any time, and now says we have a contract that governs those terms of employment. So if you want to use one, a lot of the reasons people give is it gets us better people, right? People aren't going to come to me unless they have a contract. It needs to protect my interests. I can put in there the confidentiality clauses, the non-compete, and then the wages and the bonuses are clear. I'd argue you can probably do without a contract. Not good reasons to use a contract is you want to make sure an employee will stay. If an employee is going to leave, they're going to leave. If we have to deal with the issues of non-competition agreements, other things like that, that's going to be a separate issue, but I don't think a contract's necessarily, that might help deter it. But if you're going to be using a non-compete and you think that's going to be helpful, maybe that's a reason you want to use a contract, but don't do it because you want them to stay, because you don't want a bad employee to stay. They're not happy, you're not happy, they're going to pollute the rest of the workforce. We don't want them there. Don't want to use a free form. Your contract should always be specifically tailored for your organization and for specific employees in different titles. We've always used them. Just because you've always used employment contracts doesn't mean you should continue. It's kind of like that W-2 independent contractors. We've always had everyone be independent contractors. It doesn't mean they're not employees the whole time. It just means you haven't been caught, right? So don't always use them. Employee says you have to, well, that's not something that maybe have a longer period, right? So you're not gonna be able to just terminate them at any time and any reason, but you've either got to show good cause or maybe pay them out for a longer time. So for termination, is it good cause? You have to define good cause. So it's helpful to you, right? You're writing this contract. I'm writing this contract for you. Somebody is. Make it helpful to you. Make it broad. Be very clear. And you want to use an objective standard. Is it criminal conduct? Is it violation of policies, right? If we have a handbook, which of course I think you should. Are they violating your harassment, your discrimination? Are they failing to meet expectations? Negative publicity, right? So that's pretty broad. But if someone is causing a negative effect on your organization, you should be able to terminate them, including if they have a contract. And then what are the monetary goals? What are those standards that they're failing to meet? For compensation structures, again, I don't think you have to have a contract for this. You can. It should absolutely be written. So hourly, each employee is paid for each hour worked, right? A salary, which we call salary, is really exempt. And why we call them exempt is they are exempt under the labor laws from overtime. They're expected to work the hours they have to work to perform their duties. So regardless of once they hit 40 hours a week, it doesn't matter, they keep going. Whereas your hourly or your non-exempt employees, once they hit 40 hours in a week, they have to receive time and a half pay. And then we've got our commission. Anytime you have a commission employee, there should always be a written statement that indicates how you're going to pay them. They have to be employed at time of termination. I can't tell you how many times that comes up. Make sure that's clear. And from the employer's perspective, absolutely, they should not be being paid unless they're being employed by you the date that payment is due. So yeah, that might mean they leave in January and you have the year end through December, but your bonuses and your commission, if it isn't paid right away, that might mean they don't get that money. But as long as that's clear within your documentation, that's okay. So again, make sure that's clear and it's documented. So do you want to change the at-will relationship? And understand that is a big deal because now you're not able to walk in one day and say, we're terminating you without at least considering what the contract says. Why do you want the contract? And again, what's our good cause? Make sure you're comfortable with it. Which leads me to one of the most important questions, right? So when people come to me and they have that problem employee, before it's in litigation, before a complaint is filed, we want to know, do you have employment practices liability insurance, EPLI? What that does is it covers your defense costs for discrimination. Not part of your general business insurance. It's a separate EPLI policy. Ask your representative, your broker, as to what your EPLI deductible or your retainer is, and what are your limits of coverage. I've seen deductibles from $500 to $25,000, right? Depends on the coverage, depends on what you want to pay for the policy. If you have a problem employee, if that turns into a letter from an attorney, and if that turns into litigation, you're looking at an easy 100,000 plus, right? That EPLI will help you at least pay for the cost of your counsel, your attorney during the course of that litigation. Sometimes beforehand, as soon as you get any notice of any claim by an employee, you want to forward it on to your carrier so they know what exists, right? And sometimes you'll say that happens and you make an offer to pay the employee 1 month's salary, $10,000, whatever it may be. And if it later goes to litigation, that $10,000 may be something the policy takes out. So you want to make sure you know, do you have EPLI? What's your deductible? And do you have enough coverage? I am not a broker, I don't pretend to be. However, when we look at employment discrimination claims, what we generally do is look at the salary of an employee. So it'll be super simple and say it's a $50,000 a year position. If they're terminated, the initial demand is typically 3 years of salary, gets us to 150, pain and suffering, at least a 50, maybe 100, and then your attorney's fees, which I just told you are going to be at least 100 if you're looking at litigation all the way up into the profit. So that's for a $50,000 employee, you're looking at $300,000 for that person. So is your limit of coverage and your maximum amount of coverage per incident, or is it for the year? So you want to make sure you know all those things, particularly if you're here today because you've got some red flags with an employee. Make sure the EPLI insurance is in effect now, because once that claim is made, this insurance isn't going to cover things that were made in the past. So you want to make sure you have it proactively. So that's how we deal with our employees who don't just fit. Yeah, if you can, get rid of them before the policy gets worse. I understand, of course, the amount of money, training, recruiting, the easiest of times right now to find certain employees. But again, if they're not a good fit, I can't think of a time where people regret firing. I can't think of many times where they regret keeping them on. So that's something I would recommend. When we've got performance issues, again, don't ignore them. You want to make sure you treat all people equally, right? If someone is coming into work 5 minutes late every day, you need to discipline them for that, because if not, everyone else sees that this employee is coming in late 5 minutes, right? Again, don't treat anyone differently because they have a family situation, whatever it may be. Of course, there are always outliers and there might be unique situations, but try to treat everyone equally. If you don't, because someone can't make it to work until 9:05 every day, document the reasons why. It's not because of the race, religion, gender of everybody else. It's for a specific reason, and here's what it is. And again, my favorite phrase, no good deed goes unpunished. If you allow that person to come in, and then 3 people come in late, now you've got the 4th person who comes in late every day, and you discipline them, and they happen to be the only person of color in your workforce. Now, did you do it because of discriminatory reason, or because you're just bad at following the policies, right? So that's why we want to make sure we're super consistent in informing the policies of any performance issues. I can't underestimate the importance of performance reviews, right? So people say, "Well, is that really helpful? I don't want to do it." If you don't want to do it, I know you're professionals with 50 different hats, right? At least do a self-evaluation, right? A couple of questions you send to everyone, what are the highlights of the year, where's something you can improve on, right? Ideally, you have some documented numbers, right? Like on a scale that shows what that person is doing within their role at that time. The purpose of performance reviews is we understand what the goals are now. It gives feedback, right? And then recognition. Everybody wants to be recognized for doing a good job. This is your chance to do that. Identify strengths, areas for growth, and then it can also help with career development and succession planning. And again, you understand what employees are doing. If you're reviewing their performance, you have to have some understanding of that. So how do we use them? Again, we document performance issues. So if you do performance evaluations at least yearly, which is what I recommend. So if you do them every December, if you do them every January, whenever it is you decide to do them. If you're busy in December, it's not going to happen, do it in January, right? But make sure your supervisors do it, make it a requirement, and hold everyone accountable for that. Identify the weaknesses, right? Because that's going to be used to support future employment decisions. So if you're going to do these performance reviews, and if you have supervisors who give everyone a 10 out of 10, and it gets moved on and they get their raise each year, that's not helpful. What I need is accurate performance reviews, right? Everyone has something they can, and that should be included, right? So that way, someone comes to me and says, this person's been an awful employee. They never do a good job. They just barely skate by. All right, let me see their last performance reviews. 10, 10, 10, 10, right? Versus, yeah, they don't communicate well. We've had problems with them. And you go back the last 3 years and you see documented need to improve communication skills, interactions poor with clients, whatever it may be. That's helpful to show that a termination is for legitimate performance reason rather than a discriminatory basis. Why is it helpful to you? There's a lot of different reasons, but one of them is it's transparent, right? It shows you here's what we expect of you, you're evaluating you based upon those standards. And again, that opportunity for recognition. People do want to be recognized for their good work. Anytime you give anyone a raise, I would argue they should have a performance evaluation prior to, right? So that way it's not just here's your raise, it's you've done all these things well. To reward you for that, here is your raise. We're happy to give you it. Oh, and like everyone else in the world, there's a couple of areas you can improve on, and here's what they are, right? So it's all in messaging. You can say that in a positive way that people are happy about it, or you can focus on the negative. It depends how that's done. But you want to make sure you're enhancing that motivation, the engagement with all of your employees, and treating everyone equally, which again makes it super important that from the top down, all supervisors understand there is an expectation and a requirement that they're going to evaluate all of their employees. And there's not one supervisor who gives everyone 10s, one who gives everyone 5s, right? We want to make sure we're consistent in how we're evaluating. So that does require someone at the top to look at all the evaluations to make sure they're appropriate. And by the way, change in pay right now is a big issue, right? So a lot of companies are auditing what employees are being paid to make sure we don't have a bad narrative that shows employees are paid less than men, women are paid less than men, or older employees are paid less. Whatever it may be, you want to create that audit just so you can check in on your salary and make sure it's reflective of performance, job responsibilities, and not based upon any sort of protected characteristic. Hopefully, these performance reviews will improve performance and productivity because it outlines where those improvements need to be. And again, if someone's amazing at their job, maybe that helps you identify them. You look at that evaluation and see, oh, this person's really good at a certain skill. I have a need for that now. Help you see that. Employees hopefully are going to be retained and satisfied. It's like a handbook, right? No one's going to tell you they want an employee handbook, but I think a good employee is going to want you to have an employee handbook because they know the rules of the game, right? They're entitled to know what the rules are for how many days of sick pay. They're entitled to know what is the rule on harassment and discrimination. If I have a complaint, where does it go, right? Everyone needs to have a fair set of fair rules and guidelines. So same thing with employee review. If they know everyone's going to get reviewed and they're fair and they're equitable, that helps them have some more engagement in the process. And again, it aligns with your organization's business strategy, right? That you're trying to make sure you're helping employees achieve the best they can. Of course, for increased pay if they do that eventually, if you can. But again, it helps to stay on the positive track. Again, this helps us if there's a documented history of issues. If you don't put those comments in the performance review, there's no point. But if you do, then that's very helpful. And again, proof of shared information. So a lot of people have the employees sign off, and employees really don't like to sign off on their performance reviews. And you say to them, you're not acknowledging the content, you just acknowledge receipt of it, and they say no. I would ask that they sign it. If they don't want to sign it, you just sign it with your name and the date and they refuse. If the employee wants to refute it with their own paperwork, sure, we'll accept that. Have it. Maybe there's something you didn't know about. Maybe it's just an excuse and you filed along with it. That's fine. But you want to make sure that you can show 2 years from now, yeah, this employee had the same issue for a long period of time. I can show you that in the last performance reviews. If ultimately it comes to a PIP, performance improvement plan for an employee, these performance reviews are a great way, a great foundation to say, here's the issues you need to improve on, right? A PIP is useful. A lot of people will tell you a PIP is just notice that you're going to be fired in 30 days, right? Or people will say they actually get used for the right reason. You're helping an employee get on track, right? With setting clear, objective standards with timeframes. And that's what your PIP should be. It should say, contact with how many clients within so many days. It should say X dollars of accounts in certain departments, whatever it may be. That should be clear within the PIP. Is the goal met or it's not met? And also you usually want to include in the PIP regular check-ins or meetings with a supervisor. So again, it's not just day 1, day 30, terminate. It's we met on week 1. Here's how you're doing on your goals, right? That PIP needs to be clear for that. So a PIP also is not a standardized form. That's going to be very specific for each employee and each role within your organization. And again, all of this is helpful because if you have that troublesome employee, sometimes it's not just a good fit, but usually it's based upon some sort of performance also, right? And when I say not a good fit, maybe it's a personality, maybe it's joking, maybe it's that they're not a good fit. That's okay. But if it's resulting in them not showing up on time, not performing on time, not meeting their sales quotas, then that's where we hit this performance information also. So you actually need to complete those performance reviews, and they don't have to be annually. Again, I would suggest that they're at least annually, a set time. Your employees are aware of it, and more importantly, your supervisors are aware of it. They don't need to be just annually. And if someone's having issues, it should be documented in a performance review, right? So some people give a written warning, and that serves as a sort of performance review, or you have some sort of suspension, however you go within the disciplinary process. But again, make sure you're having those documented in the performance reviews on a set basis, and they can be more often if necessary. Be honest in your reviews, right? We want to make sure people aren't giving the 10s to everybody, unless for some reason they do. But if someone's giving all 10s, it's probably a red flag to you as a supervisor to look at what that manager is doing. Why is everyone getting a 10, right? Do they want their department to look great? And probably if so, there's probably something else going on, right? And you have documented issues that now you can show I shared with that employee. Accurate support of employment decisions. Again, it's being able to show, yeah, this wasn't the first time that they were rude in speaking to a client. They had done it 2 years ago, 3 years ago, 4 years ago. We spoke to them about it, right? And you have these documented performance reviews, discipline, whatever it may be, to support your employment decision. So anytime you have a performance issue, that's the minimum of what we should be looking at. Do you want to conduct the reviews regularly again, not just annually? You want those clear, measurable objectives, ideally some sort of number scale. Talk about job descriptions. Everyone should have a job description, particularly for your performance reviews. And then we're going to get to disability discrimination. A job description is essential when you're dealing with disability discrimination because it identifies the essential functions of the job. That's super important. So in using those clear measurable objectives, we've got your job description, and maybe it outlines the 10 things, and that's what directs your performance review. There's all sorts of ways to do it. And again, you've got the balancing of your constructive feedback or areas of improvement with recognition for the things you're doing well. And it should be a two-way dialogue, right? Hopefully it's not the supervisor with a page already filled out, meets with the employee for 2 minutes. Did you read this? Okay, good, done. You want some discussion, some examples in there so that people understand how those scores were reached and how there's support for them within the records or in the work. And if there's certain actions that need to be followed up on, and say we're going to meet again in 6 months and have another performance review, or we're going to discuss where you are on this. So that way we can have an understanding as to how they're progressing on that performance review. We talk about probationary employees. And again, I'm telling you not to have probationary employees. That doesn't mean that you can't have a 90-day review period and require it of everyone. That's okay. But you can terminate them on day 22 or day 52. You don't have to wait till day 90. But if you get to day 90, and your performance review shows that there's a lot of problems, maybe you will terminate them. But if you knew that at day 30, get rid of them at day 30. Don't wait for the 90 days. You're better off spending your time training up and getting a new employee to fill that position, generally. Again, we want to use our company policies to say that, yeah, you violated this, and it's the reason for your discipline. So what policies do we typically utilize? Harassment and discrimination are the big ones, right? If anyone is treating anyone differently because of their protected category, that's unacceptable, often resulting in immediate termination, depending on the scale of how bad the offense was. Workplace violence is a policy that I'm seeing be utilized more and more now. Workplace violence isn't your typical, oh my gosh, excuse me, a fight in the hallway. And it's not even anymore someone who threatens to burn down someone's house, right? It's more subtle. Whenever there's a threat that makes a person reasonably fear for their safety, I'd say is the phrase that I like to see most often, because you've got employees who maybe someone's super sensitive and they're afraid something's going to happen without a reasonable basis. Fine. But in a lot of circumstances, someone will say a comment and then they talk about the fact that they went hunting over the weekend, right? And there's a series of events that leads to someone reasonably feeling unsafe in the workplace. That violation of the workplace violence policy can now be utilized to discipline that employee. And I know we always talk about this, 10 years ago, we didn't care what employees did outside of the office, but with social media, it's all come in, right? People know each other's Facebooks and Instagrams and whatever other things I don't know about exist out there. So if someone's commenting or discriminating against someone out here in social media land and it gets brought into the workplace, you now as an employer have to deal with it. And if it deals with workplace violence, you're going to have to discipline an employee for violation of that policy. Ethics policies are super important. Depending on your line of work, there could be financial information, other things that we want to make sure people are acting ethically. Same thing with conflict of interest, confidentiality. There's so many issues. Same thing. People always have their phones with them at all time, right? New Jersey's a one-party state. meaning at any time I could hit record on my little phone here and I'm the consenter. So now I've just recorded everything and that's lawful. Same thing with photos. People think it's okay now to, or you're like my kids and it's taking pictures of the sky or the floor, which I don't understand is a whole nother issue. They're taking pictures all the time. If you're in a workplace and I have in front of me confidential documents and now I've just posted it on my Facebook, that's a problem, right? So we want to make sure if people are breaching your confidentiality, your social media, whatever your policies are regarding that, discipline them for that. And we utilize our policies to help with that. Bullying. Bullying is not illegal in the state of New Jersey, with the exception of students in schools, right? So if someone goes to work and their supervisor is just mean to them, they ridicule them, they don't like them, they tell them they don't like their dress, there's nothing unlawful about that. They're just a jerk. If, however, they're treating them differently because they're a woman, because they're Spanish, whatever it may be, now that red flag raised up and you just went from bullying up to harassment and discrimination and unlawful. You can, as an employer, choose to have a bullying policy that says bullying won't be tolerated in the workforce. You have to define bullying, right? I've seen it work both ways, right? Bullying, it's an unclear territory, and people often feel bullied depending on your workplace when maybe it's just a supervisor trying to get them to do their job, right? So if you want to have a bullying policy, I think it needs to be very specifically tailored to what actions you want to prevent. And if you do have it, train on it, just like you would harassment and discrimination, and make sure that employees know what bullying is. And, you know, when they have that harassment, discrimination, and bullying training, which should be yearly, documented, you want to make sure that it's clear as to what that is and the complaint, how people complain about that. Do you want progressive discipline? I'd arguably say no, because for the same reason, I don't want you to have a probationary period. Always the progressive discipline policy says, right, first action is an oral warning, then a written, then a suspension, right, and then leading to termination. But it always gives management the right to retain the opportunity to terminate one at any, skip any step and terminate at any time, okay? However, progressive discipline oftentimes has a chart, right? Where if they're late to work one time, it's this, two times it's this. I have trouble seeing that in a nice, neat box, right? Because that employee who's late for work maybe had poor attitude when they got in, right? Or this is the fifth time they've done it. Whatever it may be, I have trouble putting that in a progressive discipline box. So for that reason, I don't generally like it. Yes, I totally acknowledge there's steps along the way, but I don't want it to be based on specific tasks. That's my opinion. So if you have that, I'm happy to work with you to figure out the best way to utilize that. So again, your job descriptions have to identify the core responsibilities of the job. I mean, core responsibilities like, do they have to be in the office, right? Do they have to interact with clients? Do they have to be able to type? Do they have to be able to lift 10 pounds? Do they have to be able to stand? Do they have to be able to hold patients? What are those core job responsibilities that need to be met? And those core responsibilities have to be used for evaluations, right? Can they meet them? And again, that those job descriptions and whether those people can meet them may support discipline. And again, we're going to get to disability discrimination, but the question often is whether they can meet those core responsibilities with or without reasonable accommodations. So that's what we're going to get to. So illness and disability of employees. So here is our alphabet soup. New Jersey now has required paid sick leave. We've got FMLA, which is the Federal Family Medical Leave Act, New Jersey Family Leave Act, New Jersey FLA. Notice New Jersey FLA doesn't have the M, so your own medical condition isn't covered in New Jersey. And then we have New Jersey Family Leave Insurance, which is just a payment, not a job protection. Then we've got disability, and then we've got unpaid leave of absence. That's just a quick overview of what needs to go up in your head when someone comes to you and says, I'm sick. That's a lot, right? For anybody, that's a lot. Now you've got to look at your manual. Do you have something about paid sick leave? Are you accruing it? Did you have it at the beginning of the year? Does it qualify for FMLA? Does it qualify for New Jersey Family Leave Act? Did I give them their family leave insurance? Do they qualify for disability? Is it short term? Is it long term? What does our insurance say? Oh, or do we have to give them an unpaid leave of absence? That's a lot, right? So anytime anyone comes to you, you need to be thinking of all these different things. So if someone's coming to you about all these different things and they're already a terrible performing employee, we're too late, right? That's why I go back to if something's wrong, fix it before we get to the point where someone needs to go out. When we talk about what a disability is, in New Jersey, it really is almost anything, so we have to be careful. So accrual of paid sick leave, everyone needs to have now, everyone, so please tell me you do, paid sick leave, which says you get to up to 40 hours of sick time each year. So for every 1 hour worked, for every 30 hours worked, you get 1 hour of paid sick leave, okay? You can wait 120 days, but those 40 hours max are what you're going to get each year. So bookkeepers love that, right? So now in addition to everything else, we have to either say after 30 hours they get one, 60 hours two, right? To accumulate up to that 40 hours, or you can front load the 40 hours at the beginning. So accrual method says we're going to say again, 1 hour for every 30. Each January 1, we're going to start over. If you don't use it all, do you lose it? Do you pay it out? You need to have that in your policies. If someone leaves, are they entitled their accrued paid leave? All of that needs to be in your policies now, or they're probably going to get it, or it's your past practice. And if you haven't done it before, they're probably going to get it. So it's a week pay we're talking about here. Front load method is what your bookkeepers probably prefer, and your managers for that perspective, because come January 1 or whatever year you set, here's 40 hours employee, here's your 40-hour paid sick leave. You do with it what you want, right? Simplified, you can use it on January 1. You don't have to wait to accrue it. Every 30 you get 1, takes a while. But if your employee leaves on March 1st and they've used all their 40 hours, you're out of luck, right? The fact that they use those 40 hours, that's the negative of it. So you have to decide what's best for your organization. Paid sick leave in New Jersey can be used for anything. Here's what the law says: your own or your family member's illness. But wait, who's a family member? Anyone who's the equivalent of a family member. So my best friend's daughter, I sometimes help her. So she has to go to a doctor's appointment, so I'm not going to come to work today. And I can't make it, during lunch hour. I'm going to be gone all day. That's because of a family member's illness under the equivalent. A domestic violence issue, school activities. Kid's going to be in a play, I have a teacher conference, work or school closure due to a public health emergency. Of course, during COVID, this came up, right? So guess what? I don't want you to ask what that sick leave is going to be for. That 40 hours is their given. They take it for what they want. That's my suggestion, because if you delve into it, I mean, really, if a family member is an equivalent, do you want to know who they're counting as their family member, right? What's their reasoning? I don't want you getting into that, right? I don't want the HIPAA. I don't want you to know about medical conditions. So here's their 40 hours. They're going to get it, right? So that's one thing. We've got that approval of sick leave. You can wait 120 days of employment, should be in your policy. Again, make sure you implement that fully. Are you okay with that? If an employee comes to you after 3 months and says, I really need to take some time, are you okay that they don't have paid sick leave? Make sure you understand the policy and apply it consistently. Big change also is that health provider certification, a doctor's note, can only be required after 3 or more consecutive days of absence. So how many of us have policies back from years ago where if you're consistently out of work Friday, Monday, enjoying a nice long weekend, that's not okay. That's not fair to everyone else who's in the workplace. If they do it for that first 40 hours, nothing we can say, right? Because I don't want to know the reasons, and we can only require that doctor's note on 3 or more consecutive days of absence. So it's at day 3. Also, again, for all sick notes, this isn't just for paid sick leave. All of our policies have to change to not just 1 day, but after 3 days or more of consecutive absences, that's going to trigger the need for a doctor's note. And again, if you require it for everybody. So we've got the federal overreaching Family and Medical Leave Act. So you have to have 50 or more employees for FMLA. That's the first thing. If you don't have 50, you can cover your ears for this part, right? 50 or more, up to 12 weeks in a year for a qualifying reason. Of course, you as the employer, you have your nice wall of notices, hopefully in your break room, bulletin board somewhere, and it includes the FMLA notice, right? You want to make sure that's clear to your employees. And also you're going to give notice when you know any of these things are happening. So pregnancy, birth, adoption, or foster care. That's simple enough. Care for an employee's own serious health condition, or this one's a little bit more restricted. Care for this serious health condition of an employee's spouse, parent, or child. Military family leave, that's a little bit trickier, that's new, but that's something that's also allowed for. And then that serious illness or injury of a military family member also. So that's family medical leave. And again, it's spouse, which includes same-sex spouses, a parent, it doesn't include in-laws, and a son or daughter up to 18, unless a son or daughter over 18 has a disability and is incapable of self-care due to that disability. So again, if you know someone's child is older than 18 but has a disability, they're going to count as family members under FMLA. So for military families, it can actually go up to 26 weeks if they need assistance. That's federal. Now we've got New Jersey. New Jersey Family Leave Act says that if you have 30 more employees, so FMLA, you have to have 50. Now, if you're down, but you don't have 50, but you have 30 or more, now you're under the NJFLA umbrella. NJFLA says if you have 30 more employees, they can get up to 12 weeks of leave now in 24 months, or 2 years. FMLA, the federal, is 12 weeks in 1 year. New Jersey is 12 weeks in 2 years. So birth of a child, placement, adoption of a child, or the serious health condition of a family member. It's not for your own condition, right? If the employee themselves has cancer, they're not going to take NJFLA. They might take Family Medical Leave Act. However, if their spouse has cancer, now they can take it under NJFLA. That's the difference. You're not required to continue health insurance under NJFLA, but if you have other benefits that would continue under temporary leave, whatever your policy says is going to govern. Separately, we have New Jersey Family Leave Insurance. So what that is, it's just a payment. It doesn't protect your job. It just says we're going to provide you up to 12 weeks of pay, either straight time or intermittent 56 days, for the time that you're out, right? So Family Medical Leave Act, the federal, allows for that job protection. And so does the NJFLA, no pay, but here's your job protection. You have to come back to the same or similar position after 12 weeks or whatever it may be. New Jersey Family Leave Insurance just says we're going to pay you. It's almost like temporary disability. That's family leave insurance. So in New Jersey, we've got to apply with both Family Medical and New Jersey Family Leave Act. And they can run concurrently, right? So when you're using both FMLA and NJFLA, it can lead up to 24 weeks. So that's 4 weeks in a month, 6 months, right? Because if an employee goes out for their own medical condition related to a pregnancy, say, and they get out 12 weeks, the baby's born, now they've got 12 weeks for someone else's serious medical condition if there's an issue there. That's how you get to a 24-weeker. So you want to make sure you're running it concurrently. You want to make sure notice is provided. I could talk for hours about NJFLA and Family Medical Leave Act, but I think the most important things are make sure you provide notice as soon as you know someone has a health condition that may trigger their rights to job protection under the FMLA or New Jersey Family Leave Act. Give them that notice, give them the forms to fill out so they can apply for those leave provisions. If not, there's a chance that they can get that leave additionally. So they're gone for 6 months and you realize, oopsie, I forgot to give them their paperwork. You give it to them. Now do they get another 12 weeks? That's why you want to make sure you're providing notice to employees as soon as you're aware of their need, possible need for family or medical leave. Public notice, and then again, written notice. So at the time of hire and upon learning of the need for leave. So generally the advice is when someone's gone for 3 or more consecutive days of work, that's probably or maybe something that qualifies for FMLA. We send them the form. If they don't send it back, they don't send it back. If they say, no, I'm fine, I just had a cold, fine, right? But you've at least met your requirements to provide that written notice so they understand they can take that leave if they need to. So I know when I go through employee handbooks, people who haven't looked at them for a couple of years have maternity and paternity policies, right? So they say maybe you get 3 months and you've got separate. So if you have a separate maternity and paternity policy and you're bound by New Jersey Family Leave Act and the Federal Family Medical Leave Act, and you're bound to the 40 hours of paid sick leave, that's a huge chunk of time that employees are allowed to take off each year. So basically, whenever I find those maternity, paternity policies, people usually want to get rid of them and instead include them in their sick time, which again, doesn't have to be just 40 hours. It can be more than that, but include it in there so that it can't be in addition to. People who want to use PTO banks, that can be effective and that can work, but it must meet the requirements of all the other laws. So again, you have to accrue or have available at the beginning of the year those 40 hours, and they can be utilized for any of the reasons, right? If you have a PTO bank that says you actually need to be sick, or a sick leave policy that says you can only use it for your own sickness, and you find out the employee's in Aruba, not okay under your policy. But if they're there because they're celebrating something related to a school project or whatever it may be, remember those 40 hours of paid sick leave? I don't want to know. You want to make sure your PTO bank clearly identifies what the use can be for. So that's not too restrictive, because if so, then the state can come and audit you and say you're not providing the necessary 40 hours of paid sick leave, and you don't want to pay that for each employee. So disability discrimination and accommodation. So in New Jersey, we've got the law against discrimination that governs and protects, and it's one of the most encompassing across the country. We're up there with California, New York, that almost anything that can be protected is, whether it be pregnancy, whether it be genetic identity, right? As well as the standard ones that are provided under the federal law. But the federal law is more restrictive. We're a little bit more It's broader in New Jersey. So it applies to nearly all employees, regardless of size. The law against discrimination doesn't have a 10-15 requirement. And what that New Jersey law against discrimination says is we can't discriminate against or treat people differently because of their disability. We can't refuse to hire them, promote them, grant tenure, right? Whatever it may be, terminate or lay off employees because of their disability. And so maternity, childbirth is considered a disability, right? So if someone doesn't come back to work after a baby, is it because of that, or is it because of 50 other reasons, or is it the fact they never reported back to you? The only way we know is you're going to document, right? Retaliation against an employee due to a request for accommodations. Again, retaliation is a big area, so you need to make sure we're being clear that that's not the reason for any employment action. Someone requests an accommodation, we have to engage in that interactive process. We're going to document it. And if any action is taken because that accommodation request can't be met, we need to make sure we explain why so it's not seen as retaliation. And then actions of disability discrimination are subjecting employees to harassment or creating a hostile work environment due to that disability, right? And that comes back to training, I think. Again, harassment discrimination training should be every year. It's going to include disability discrimination, and it comes from the top down. And your supervisors have to understand, and they have to make sure the workplace understands we're not going to discriminate against someone or create a hostile environment for someone based on their disability, right? And case law has even expanded that further, or it's not even their disability, it's their perceived disability, right? So it's not even the fact that they have back pain and can't perform some actions if someone teases them because of that, right? And they say, oh, are you gonna be able to do your job today, right? Or whatever it may be. We don't want a hostile work environment based upon the fact that a person has a disability or a perceived disability. Maybe they can perform, but the employees still tease them anyway. It's up to the workforce, training, and supervisors to make sure that doesn't happen. So the definition of disability is very broad. So it's based on actual, perceived, or history of a disability. And a disability includes physical, mental, psychological, and developmental conditions. I'm sure I don't have to tell my HR professionals out there that a doctor will write a note for almost anything, right? Including urgent care. So my favorite is, so you're telling me this person came into you today and you know they're going to be out for the next 6 months because of this headache, because of their back, right? We get these documents, right? And there's certain people who are repeat offenders, but when you get that document, you now have in your hand someone who's been provided something by a medical provider. We can't discriminate against them based upon that, right? And there's a whole nother issue as to how can we ask further information, right? That again is where your job description comes into play, because we can send that to that physician who wrote that note and say, here's the job description. Can they meet that or not? What are the accommodations that would be reasonable? Temporary conditions such as COVID-19 are also considered to be a disability, and even conditions in remission like cancer or if someone has MS can be considered a disability. What it's not is if someone has a broken leg, right? Some sort of temporary thing. It's not considered a disability, but it can be, right? Someone's wrist hurts and then they have carpal tunnel, then they have carpal tunnel surgery. Now it's resulted in something that is now a permanent, arguably, and can meet the threshold of a disability. So you, the employer, have an obligation to engage in an interactive discussion and provide reasonable accommodations, right? What's reasonable? What's reasonable is whatever the jury of 7 people sitting in New Jersey court decides is reasonable, right? I don't know who it's going to be. I don't know which county I'm going to be in sometimes. I don't know if they're grumpy or not. So if I have a question as to whether it's reasonable or not, my red flag is going to go up. I'm going to document, I'm probably going to call counsel and make sure I have an understanding as to what a reasonable accommodation is, because that's what the law reads, right? As long as the employee can perform the essential functions of the job. How do we know the essential functions of their job? Here's my job description, right? Here's my job description, doctor. Can they meet these job requirements? And it has to not create an undue hardship on you. So there's a lot that goes into that, right? But again, reasonable, essential functions, and not an undue hardship. So once an employer is aware of the need for accommodations, they must engage in what's called an interactive discussion. So under New Jersey law, if someone files a complaint for disability discrimination, they'll include violations of New Jersey law against discrimination, right? Maybe violations of federal law if they're going to go to federal court. They'll also include failure to engage in interactive discussion. It's actually a separate count under New Jersey law. So that's why it's super important. If someone comes to you, they don't have to say interactive process. They don't have to say disability. They don't have to say reasonable accommodation. But as soon as you know or should know that there's an obligation to engage in that interactive process, you absolutely need to start the process and document it the whole way through. Sometimes there'll be a workable solution. Sometimes there won't be, right? So what do? You discuss the employee's limitations, you discuss the tasks. Not only you, the employer, have the obligation to engage in the interactive discussion, but the employee does too, right? I've had instances where the employer says, like, I understand you're having trouble. What can we do? Let's discuss it. Can you please, here's a copy of your job description. Please have your doctor fill it out. And they never do. They just say they can't do it. Okay, well, then they're not engaging in the interactive process, and your liability just lessens when you make the decision to terminate, right? But you want to document that you've done that you engage in the interactive process. What are their limitations? What are the job tasks? What are the accommodation options, right? And again, document, document, document. And I always feel like it's important to have a notebook or a yellow pad by your desk, right? And an employee's name maybe has a couple of pages, or maybe it's daily. Here's the date we met, here's what we discussed, here's when we requested the doctor's note, right? All of that information. So 6 months down the line, when they say you weren't providing me a reasonable accommodation, you can show, here's all the times I asked you, here's all the time we documented it, here's all the times we met to discuss what a reasonable accommodation was for you. And those are things that take a while. They do, because of, physicians, the top thing on their list isn't to fill out these forms, but they do need to be completed. And so you have to provide your employees a reasonable amount of time, but they do have to have a conclusion. So what are reasonable accommodations? It could be adjustment to work hours, right? If some people have certain issues because of the medication they take, they can't get there at 8 o'clock in the morning, and all you have to do is allow them to start at 9. That's probably a reasonable accommodation. Yeah, you're going to piss off everybody else who has to be at 8. Don't think I don't know that, but that's where you tell your employees that's a confidential personnel decision. You show up at 8, they're going to show up at 9. Right? That is what it is. And there's a reason for that. And you're going to document that. And that's not for discriminatory reason. That's for a documented reason due to a person's disability. That's the difference, right? Remote work, toughie, right? Everyone wants to work remotely. If you let somebody do it, does that show that everyone can do it, right? So that's a difficulty, and you want to make sure, again, what your job description say and why does that person need remote work? If it's short term because they're recovering from an infusion, because they broke their leg and they can't walk, right? Additional breaks are also a reasonable accommodation for medical treatment, similar to breastfeeding and things like that. You can provide a leave of absence, paid or unpaid. It can be under FMLA. If you do it under FMLA, even if you don't, you want to make sure, again, you provide that notice. And then workplace modifications. Maybe you have stairs, so they can't get into the office and they can't walk, so then you add a ramp. Maybe it's providing special keyboards. Maybe it's those fancy chairs that support your back more. Maybe it's a carpal tunnel keyboard, adjusting desks, whatever it may be. Those are probably going to be reasonable accommodations. Other ones are job restructuring, right? So this is tougher. Reassigning non-essential duties to other employees, right? So what we want to look at typically is you think about vacant positions and needs. And if there's an employee who is unable to lift things, right? So they can't bring in the supplies, but they can do a checklist, whatever it may be, we can restructure, but you want to be careful and you want to make sure you're treating the non-disabled employees equally. So you want to be careful for that. Assistive technology can get costly. If it's something very simple, then that's reasonable. If it's something that's cost you hundreds of thousands of dollars, maybe that's not so reasonable. So it depends what it may be. And again, reassignment to a vacant position, you don't need to create a new job for this person. However, if this person is able to perform, they were a file clerk, but now the receptionist duty is open and they can do that, then that's fine. You can reassignment to that position. If, however, they're only, this one's often happened. The doctor says, cleared to return to work for light duty. See you again in a month. What's light duty? We send you the job description. We say, can you please complete our ADA form as to what reasonable accommodations are? And they say, that they can only perform light duty work. What does that mean? And do you have it? If you don't have it, that's okay. They can't come to work. It's either you do it or you don't. If you don't have light duty, you don't have light duty, but you're going to document that you don't have it. You haven't offered it to anybody else, or there's not a need for it now, right? So you can explain that that's not disability discrimination. It's consistent. And you only have to do this if it doesn't create an undue hardship for you as the employer. So what is an undue hardship? It's a significant difficulty or expense for your business. Again, quite vague, right? Case by case basis. How big are you? What are your operations? What's your budget like? What are your profits like, right? That's all taken into consideration. So before you make a decision to deny an accommodation request based upon it constituting undue hardship, you want to make sure we have that discussion. There may be times where an employee can't come to work and you need them to be at work. It might be because they literally have trouble walking and you need them to be at work. That might be reasonable, but we need to make sure that we are able to document the reasons that they're not discriminatory. A lot of employers nowadays are also providing for unpaid leaves of absence because, okay, that's fine. Let them go take care of themselves, come back. It makes me nervous for a lot of reasons. Um, you can do it. If you have a company policy, you can do it. But again, treat everyone the same. So are you okay doing that for everyone who needs to? Maybe you can only allow it for a certain amount of time, right? Because your operations need to continue, but it's for a specific amount of time without pay. It's a break in the record. It allows for that employee to come back within that certain amount of time, but maybe operations change and you don't want them back. Maybe you don't have a need for them anymore. So if you're going to allow for leave of absence, make sure you know the reason for the leave. You want to know the length of service, right? Maybe they have to be employed 5 years before you're going to allow them to do this, right? So you know who this employee is before you allow a leave of absence. Look at their job performance. Don't allow them to take a leave of absence if they're under a performance improvement plan, if their scoring needs improvement on their evaluations, whatever it may be. And then what's the effect on your operation, right? Like your manager on the floor probably can't leave for leave of absence and you guys operate, right? So what are the requirements? And again, this goes back in the interactive process. Anything else you want to include in your leave of absence policy, have a written policy, follow it. Absolutely require that employee to use all paid leave first, or if not, they come back and then use it. And then there's an additional amount of time before you know that you need a new employee. Submit it in writing, supporting documentation, meaning doctor's notes, backups if you need it. And again, everyone should have the same benefits, whatever it is. If you're allowing health insurance to continue with the same contribution rate, if they need to pay it all, whatever your policy is, make sure that's consistently applied to everybody. Reinstate to their former position or a similar position. Now, when we talk about FMLA and New Jersey Family Leave Act, when someone comes back, it has to be the same position or substantially similar position, which gets tricky, right? Because what you as the employer might think is substantially similar is different to them because they're sitting next to Peggy, who's not doesn't have the same seniority, right? So when you bring people back, it can be tricky and you want to make sure you look at, is it substantially similar? And the most important thing is pay, right? Because if that employee is provided the same compensation, they still can argue that it's not the same and the location's different or the work is different, but their damages are pretty restricted there if they haven't suffered a change in actual compensation. If an employee doesn't come back again, you want to make sure you terminate them and you want to make sure you document that termination. Whistleblowers. So whistleblowing is common in every state, but New Jersey, it's called SEPA, Conscientious Employee Protection Act. And what that does is provide an avenue for employees to make complaints with protection, understanding they won't be retaliated against for that. Huge area right now, where we're seeing a lot of employees understand that they have the right to whistleblower protections and want to make sure that it's done. So in New Jersey, the Conscientious Employee Protection Act, or SEPA, only applies to employers if you're private 10 or more, or all public employees. You have to have 10 or more. You can't retaliate against an employee who discloses, objects to, or refuses to participate in, or reasonably leaves, there is a violation of public policy, right? So again, they have to reasonably believe. So even if it isn't a violation, but someone made a complaint, you can't retaliate against them, right? If it's a reasonable belief. And that's New Jersey's whistleblower. An employee can't voice a concern of a law, rule, regulation, or policy, and reasonably believing that, and then they can't be retaliated against for that action. So you can't discriminate, again, this is what I just said, you can't retaliate against employees who disclose or threaten to disclose an activity or practice that they believe is unlawful, or provide testimony basically to support that unlawful activity, or object to or refuse to participate in any activity that they believe is wrongful. And they can be wrong, right? I'm not going to file on this report because I think it's against the law. It's wrong. Well, you can't retaliate against them if it was in good faith. You can retrain them, right? And you can make sure that they have an understanding next time. But for that one first instance, if it's a good faith belief, that's going to be protected under SEPA. There are requirements under the law, which is why I always like to include the SEPA part, annual distribution. So that means you should have a list of documents every January that you provide to your employees. One of them should be an employment practices or employee handbook sign off, right? Acknowledging receipt of it again every year. Another one should be your SEPA notice. They have to get it every year. And your SEPA notice needs to include a specific named individual because people have to know who they can complain to. That's the point of the law. And it always has to be two. Just like harassment, discrimination, same thing with whistleblower. Because if you say report to your manager, but the manager is the person you're complaining about, there has to be an alternative, typically HR or another supervisor or a board member, whatever it may be. Need to have a signed acknowledgement of SEPA yearly, and it needs to be conspicuously displayed. So again, that bulletin board. If you have a substantial Spanish speaking group of employees, it has to be So how do you prevent SEPA claims? How do you prevent if people think it's that reasonable belief? You document all your performance issues and show, yeah, they didn't want to sign the form and they said they didn't need to do that, but it's part of their job. We've documented they failed to do it multiple times, and now they're just trying to get themselves protection when they failed to do their job. You want to have clear SEPA harassment and discrimination policies. What's the definition? Who do they report to? And it'll be investigated confidentially to the extent possible, prompt, thorough, impartial, right? Have an effective complaint policy. You want to make sure all your employees and supervisors know, right? What you don't want is a supervisor who says, I hear you. I don't want you to rock the ship. I'm just going to go ahead and put this to the side for now. It's better for you in the future. Still happens. It still happens a lot because people are worried about it, right? They want to keep their job. Make sure your supervisors know they're not going to get punished if they forward on the documentation they're supposed to forward, right? Someone makes a complaint, let's deal with it. We don't want you to hide it. We need to monitor the workforce to make sure people aren't concerned about retaliation. This is probably too small for you to see, but it is it's the state form, Conscientious Employee Protection Act. You can Google it and find it. And then you see on the bottom there, that contact information that needs to be completed. And that is required to be posted and then again, annually distributed and signed off on. You want to make sure you have a strong culture where people understand that if they have concerns, they can express them, right? To HR, to their manager, whoever the right person is. We want to make sure that the people have training on harassment, discrimination, and the SEPA, the whistleblower, so they know where to go if they have concerns. Again, document performance reviews, document decisions, so they're not retaliation for any complaint, right? So oftentimes an employee is going through the progressive discipline system where they're not meeting the goals, they're unable to accomplish the reports. Then all of a sudden they've decided they think something is wrong and they file a SEPA complaint, right? Now they put themselves into that box of protection. How do we show, even though they're in that box of protection because they filed what they can argue is a good faith, what they believe in good faith to be a violation of company policy, we can show that's fine, but they didn't make that concern until after they received all this progressive discipline and all these issues. And by the way, they're still not performing their job, right? We want to be able to show that. Make sure we handle complaints carefully. And we want to make sure when there are SEPA complaints, we wrap back around to that employee to let them know that they have been heard. So that is the conclusion of our slides. I hope I gave you some tips on how to deal with challenging employees because it is not easy. And really, it's one of those areas where every circumstance is different. But what you want to remember to do is document, 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 be consistent, and make sure you have policies to support you. I am available if anyone has any questions. We are going to post this presentation as well as the slides on the LCR website, and you'll get a certificate from Michelle when she gets back from vacation next week. I also wanted to let you guys know, any of you out there who are small businesses, Laddie Clark and Ryan is partnering with some other small businesses, and we're hosting a small business forum on October 29th from 4 to 6:30 at Perona Farms. And we're going to have short speech. I'm going to speak a little about employment policies to have an effect. We're going to have a banker there with different things that are helpful for small businesses. So if you're interested in that, please do reach out or take a look at our website. I wish you the best of luck. And again, please reach out if you need anything. Thank you.